Hello, my name is Shannon Soignier. I am a workers' compensation and auto accident attorney in Durango, Colorado, and I thank you for joining me for this presentation on Colorado's workers' compensation law. If you're injured on the job in Colorado, the first thing you want to do is to file a claim. You should notify your employer in writing within 4 days of your work injury. If you were injured more than 4 days ago, you should still notify your employer in writing. You should also report the injury directly to the Division of Workers' Compensation by filing a workers' claim for compensation form. This form can be found on the Colorado Division of Workers' Comp website. You can also contact a Colorado workers' compensation attorney to help you to file this form. You should always keep copies of all records for yourself in a workers' compensation claim. Once you have reported your claim, the next thing you will need to do is choose a doctor. Your employer is required to give you a list of up to 4 doctors or clinics from which you may choose as your authorized treating physician. This list is known as the designated provider list. You must choose to see one of the providers on the list. If your employer does not provide you with the written list within 7 business days of you notifying your employer about your injury, you may choose your own doctor. Your workers' comp doctor is known as your authorized treating physician. In the world of work comp, your authorized treating physician is like a primary care physician. Your authorized treating physician will make referrals for you and will be the ultimate decision maker on your ability to work as well as return to work. You should work with your employer to find the best time to schedule your doctor's appointments. If you miss time from work due to appointments, keep track of your hours. You can submit the hours you missed from work to your adjuster, as you may be entitled to lost wage benefits for time missed from work to attend medical appointments. If your authorized treating physician refers you to other doctors or specialists, the insurance company will need to approve this referral. And although you may be seen by another specialist, the ATP will review and be responsible for your treatment. After you have notified your employer of an injury, the claim is sent to a workers' comp insurance provider. The workers' compensation insurance provider can either submit a general admission of liability, which states that they accept the claim, or they may deny the claim. If your claim has not been denied, your bills should be sent to the claims adjuster. Typically, the healthcare provider will do this. In order to ensure that the healthcare provider is sending your bills to the workers' compensation insurance carrier, you should provide the healthcare provider with the contact information and claim number for the insurance provider. Remember to always keep copies of everything for your records. If you have received a notice of contest form, this means that your employer and the insurance provider have not accepted liability for the claim until they can investigate further. They may not authorize and pay for treatment until their investigation is complete, but they may also pay. It's important to speak with a workers' compensation attorney to preserve your rights. If your claim has not been denied or you haven't been sent a notice of contest, you should not be receiving medical bills or balance due statements from any doctor. It is unlawful for a workers' compensation provider to send a claimant a bill when there is an open workers' compensation claim that has been accepted. If your claim is denied, it is important to communicate with your adjuster to see if they are denying your medical treatment or if they have not completed their investigation of your claim. As stated earlier, they may submit a notice of contest, but still pay for medical care until their investigation is complete. If the respondents deny your claim, you have the right to file an application for hearing or an application for expedited hearing. The procedure for filing this application is online at the Colorado Division of Workers' Compensation, or you can contact a Colorado workers' compensation attorney to help you with filing an application for hearing. You must file the workers' claim for compensation form within 2 years from your date of injury. Additionally, if you do apply for a hearing or an expedited hearing, it is highly recommended that you hire an attorney to help you with your case, an experienced Colorado workers' compensation attorney to help you with your case, as your hearing will be held before an administrative law judge, and you must adhere to all rules of procedure for the administrative law court. If your claim has been accepted and you're losing time from work because of your injury, you may be entitled to either temporary total or temporary partial disability benefits. Temporary total disability benefits are provided when your doctor states that you cannot return to work. Temporary partial disability benefits are provided when your doctor says that you can return to work for either a limited period of time or with work restrictions. The insurance company and your employer will not pay lost wage benefits until you have missed 3 shifts from work. This waiting period will be reimbursed if you miss more than 2 weeks as a result of your injury. Workers' compensation benefits are based upon your average weekly wage. It is calculated from all of your wages, including overtime, vacation, sick pay, and earnings from the job where you were injured, and earnings from any additional jobs you had at the time of your injury. If your health insurance is canceled, your average weekly wage is increased by your COBRA benefits. COBRA benefits are continuing group health benefits provided under a group health plan for limited periods of time under certain circumstances. Workers' compensation benefits to replace your lost wages while you're out of work are 2/3 of your average weekly wage and are paid if there is no notice of contest and your doctor has placed you on work restrictions. It is important to notify your attorney of any additional jobs, overtime, vacation, sick pay, and COBRA benefits that you may be receiving, so that the average weekly wage and work comp benefits may be calculated correctly. If you spend any money out of your pocket on your care, the respondents should reimburse you in most cases. They may reimburse you for travel expenses such as mileage and parking. Colorado law states that a workers' comp carrier should reimburse you for every mile driven to and from doctor's appointments. Additionally, as stated earlier, you may be entitled to reimbursement for pay for the hours that you miss going to and from appointments. This would be paid at the 2/3 of your wage amount. The insurer and the respondents may also cover the cost of medical supplies and over-the-counter medications recommended by your doctor. You should keep any and all receipts related to medical supplies, parking, or any other money that you spend related to your workers' comp injury. Typically, things like child care are not reimbursed. You should request the reimbursement in writing. Keep track of your receipts and mileage to and from the pharmacy as well, and your authorized medical visits. You should send this to your adjuster within 120 days from the date of the expense. However, if you do not send it within 120 days, you can still submit it. And remember to always keep copies for your records. Temporary partial disability is paid when you return to work, but you're not earning your normal pay or working your regular hours due to your injury. This includes missed work for medical appointments. The amount of TPD you will receive is determined by subtracting the amount you were paid from the amount you would have been paid if you hadn't been injured. You should contact your attorney to let them know you are not earning your pre-injury wages so that your attorney can assist you in getting the proper temporary disability benefits that you are owed. Temporary total disability benefits are paid at 2/3 of your average weekly wage every 2 weeks. TTD is due if the doctor takes you completely off of work or if the doctor gives you restrictions that your employer cannot accommodate. For instance, if your job requires you to lift 50 pounds or more on a regular basis, and your doctor states that you're unable to lift more than 20 pounds, this would be a restriction. If your employer is unable to accommodate your restriction, then you are entitled to temporary total disability benefits. Additionally, sometimes an employer will provide you with work within your restrictions, but pay you less than what your original job paid you. If this is the case, the workers' comp carrier will pay for 2/3 of the wages that are missing from your pay due to your work restrictions and the accommodation. If you're having difficulty performing your duties, you should contact your doctor immediately. You can never take yourself off of work. If you stop working without your doctor's approval, you may not receive benefits for this lost time, and you may risk losing employment as well as your temporary total disability or temporary partial disability benefits. Your doctor may say you can go back to work with certain restrictions. If your employer can accommodate your restrictions, they may offer you modified duty. If your employer offers you modified duty, but you are not able to perform the modified duties due to your injury, contact your doctor, as well as your attorney or adjuster. If you take yourself off of work or refuse an offer of modified duty, you could lose your lost wage benefits and lose the chance of receiving unemployment benefits once your workers' comp case is closed. If your employer is unable to bring you back to work within the doctor's restrictions, you may be entitled to TTD benefits. If you're returned to work for a new employer, you must notify your adjuster. Failing to do so could result in an overpayment requiring repayment. Many people have more than one job, and an injury at one job can have an impact on your employment at your second job. If you have a second job at the time of your injury, you should notify your attorney or adjuster immediately. If you are able to work for one employer but not the other, be sure to notify your adjuster or attorney immediately. If you are losing wages from your second job, you are entitled to some benefits. Therefore, it is very important to inform your adjuster or attorney of all employment as well as provide proof of wages for your second job. There are numerous things that may affect your benefits. Benefits received under workers' compensation are not taxable. Permanent disability awards are not taxable. If you settle your workers' compensation claim, this is also not taxable. However, you must inform your adjuster or attorney of benefits you receive outside of workers' compensation. This may include, but is not limited to, unemployment insurance benefits, Social Security disability insurance benefits, employer-paid short-term disability benefits, or employer-paid long-term disability benefits. Your benefits may also be reduced or terminated based on the following reasons. If you were injured because you violated a safety rule, your non-medical benefits may be reduced by 50%. For example, if you're required to wear a safety device such as a hard hat, a harness, or safety glasses, but fail to do so and you are injured, your non-medical benefits will probably be reduced by 50%. If you intentionally mislead your employer about your ability to perform a job and are injured, you may be fired from your job and lose all temporary disability benefits. If you test positive for unauthorized medications, drugs, and/or alcohol, your non-medical benefits may be reduced by 50%. Additionally, if you have a child support judgment against you, your benefits will be garnished for that to satisfy that judgment. Maximum medical improvement is a point in your claim when you no longer need additional treatment or treatment will not help improve your condition. The doctor may recommend maintenance treatment to keep you at your current condition. Once you have reached maximum medical improvement, your doctor will provide you with an impairment rating. If your doctor believes that the injury has resulted in long-lasting permanent impairment, your doctor will provide a rating of the impairment or refer you to another doctor who will. An impairment is a loss of function of any body part or body system. You do not need to be disabled or completely disabled to have an impairment. Once you have been placed at maximum medical improvement, your doctor determines the amount of loss in the form of a percentage. If your doctor is unable to do this, they may refer you to another doctor who can. Impairment is the permanent loss of function of a body part or system. Your doctor determines the amount of loss you should receive. Permanent partial disability or medical impairment benefits are those benefits that compensate a claimant for permanent loss of function or impairment to a particular body part. The amount of PPD you will receive will be calculated using the percentage of loss determined by the doctor and the Colorado state statute. Permanent total disability means you are unable to earn any wages for the rest of your life. Benefits for PTD are paid at the same amount as temporary total disability benefits. It is important to contact an attorney if you believe that you are permanently totally disabled due to a work injury in order to receive all the benefits that you are entitled to under the system. Colorado workers' comp statutes allow for disfigurement awards. You may be entitled to a disfigurement award if your injury results in serious and permanent disfigurement, like scarring on parts of your body that are visible to the public or a permanent limp. You may file the request for disfigurement through the Colorado Division of Workers' Compensation. It must be 6 months from the date of injury or surgery. If a final admission of liability has been filed, you have 30 days to request a disfigurement hearing, even if it has been less than 6 months from the injury or surgery. If your Colorado workers' compensation claim has been closed, you may apply to reopen your claim if you believe you need more medical care and/or temporary disability benefits after your claim was closed. The request must be filed within 6 years from the date of your injury or 2 years from the date the last benefits became due and payable, whichever is longer. If these dates are passed and you need only further medical care, you may apply to reopen your claim at any time within 2 years of the date the last medical benefits became due and payable. You can only reopen a claim if there has been fraud, an error, a mistake, or a change in your condition. In conclusion, if you are injured on the job, it is important to protect your rights. A Colorado workers' compensation attorney can help you to protect your rights. Do not assume that a claims adjuster will assist you with protecting your rights. Keep yourself informed and contact an attorney.